আপনি ইউটিউব লিংকটাও তো খুলবেন তো?
আমি
হ্যাঁ নির্মল দা, এখানে তো জুমে আছি আমরা, তাছাড়া ইউটিউব
ঠিক আছে, আমরা একটু ওয়েট করি আর একটু সবাই আসুক।
হ্যাঁ আরেকটু আসুক। হ্যাঁ হ্যাঁ আরেকটু লোক,
উই ক্যান ওয়েট।
হ্যাঁ হ্যাঁ ওয়েটিং রুমে অনেকে আছে, দেখছি কারা আছে। অরুণ মাঙ্গলিক, চন্দন পাল, কবিতা ভট্টাচার্য, নারায়ণ জ্যোতি, জয়দেব সেনগুপ্ত। Where is Dr. Balwa?
Yeah, I am there.
Oh, yeah. Good evening, sir.
Good evening.
Good evening, sir.
You are able to see me, no?
Yeah, we have our president here, Dr. Nirmal Maji. He is the Minister of Labor.
Yeah.
And Government of West Bengal and President of our IMA Calcutta, then also West Bengal Medical Council. He's a member of MCI, also the President of the Pharmacy Council. Okay, so he is there. And Nirmal Dr. Balwa.
Yes, sir. Good evening. Very good evening. My best wishes to you.
Yeah, thank you, sir. Thank you, sir.
Yes, sir.
He is a very senior and globally accepted, and he has joined from Dubai.
My regards to you.
Thank you, sir.
And to your
I thank
family
you very
members,
much.
my best wishes. Okay, sir.
Thank you, sir.
Namaskar.
Dr. Balwa, you are going to speak on
WBMC, Medical Council.
medical legal portion, that is the telemedicine.
WB Medical
Yeah.
Council.
Yes,
WBMC.
and definitely for the Consumer Protection Act, after my lecture, we want to hear from you where the doctors stand in the Consumer Protection Act.
Okay, fine, I'm fine. Fine.
Yeah, you are going to summarize.
Yeah, sure. I'll do that.
So, any more people in the waiting room?
Hello. Mila.
Any more people in the waiting room?
No, ma'am. It's open now, so anyone can join.
Okay. So, should we start off?
Mr. Arora, you are on mute.
I think we should start off, okay?
Mr. Arora,
Yes, I think it's right.
Yes.
A very good evening to all of you. Myself being the secretary of IMA Calcutta branch, it is my proud privilege to get an opportunity to hold this medical legal webinar today. And our thanks goes to Apex Medical Legal to support us. And we have with us a very eminent legal expert, Dr. Mahesh Balwa, and we have also Dr. Mittal. Both of them are legal experts. Dr. Mittal will moderate the session and Dr. Balwa as a speaker and myself for the second session. And for the foremost, may I welcome our president, Dr. Nirmal Maji. He is, everyone knows him. He basically needs no introduction. He's the president of IMA Calcutta branch, past president of Bengal IMA, and president of West Bengal Medical Council, member of Medical Council of India, then president of the Nursing Council and Pharmacy Council of West Bengal. So over to Dr. Maji for the welcome address and inaugurating the program.
Good evening, Mr. Baldoa. He is the most eminent global expert. Mr. Bijoy Arora and Vinit Mittal, and of course my secretary, Dr. Mosumi. Uh, uh, behalf of West Bengal government and our Chief Minister, Honorable Chief Minister and Health Minister, Ms. Mamata Banerjee, I, as a Minister of State, I am welcoming you. My best wishes, regards to seniors, especially to Mahesh Baldwa and Vinit Mittal and many others participants in today's webinar. And the most important topic on this very auspicious evening, the now telemedicine and medical legal points of view. We will, all of us will be enriched in this discussion. Let us start the discussion. Very good evening, my best wishes from the core of my heart to you all. And let us start the webinar.
Thank you, Dr. Maji. Now, in this, we have, in fact, two sessions. The first is on medical legal aspect of telemedicine, and the second is the Consumer Protection Act that has been enacted in 2019, and where we doctors stand. That is another very important issue that will be discussed. Now, I pass over, I welcome all the doctors who have joined here in this chill winter, and hope you will enjoy with a lot of take-home message with the legal experts. Now, I call upon Dr. Vinit Mittal. He is also a legal expert to moderate this session. So, Dr. Vinit Mittal, please. Dr. Vinit Mittal, kindly unmute yourself.
We can hear.
Dr. Vinit Mittal, please. I can see you, but you unmute yourself.
Not allowed, not allowed. Mr.
Yes,
Mr.
yes.
Yeah, now
Yeah.
I can hear you.
So,
Fine.
Good evening,
Good
respected Dr. Maji, Dr. Moshmi.
Good evening, sir. Good evening, sir. Very good evening.
Dr. Baldwa and the other participants of Apex Medical Legal Consultant, Mr. Arora and Mr. Jay Pandey. This session is a very unique session. We all doctors know that we are facing a lot of legal challenges while treating patients, either in the practice or in the hospital scenario. In spite of all us knowing that what are the legal issues, but we are not able to practice on a day-to-day basis, we do not have the smaller tips to understand where we stand on the medical legal aspects. With the Consumer Protection Act coming into force, and doctors being taking a part of that under the medical legal aspects and being tried under the Consumer Protection Act in the various court of laws, I think it's very relevant that we understand what are the challenges we face today and how to overcome those challenges. And for this, we have an eminent speaker, Dr. Baldwa. Dr. Mahesh Baldwa is a unique example who is a pediatrician by itself and a practicing pediatrician. He's LLB, he's done LLM, he's got numerous degrees in the various management and legal issues. He's a practicing doctor, he's a teacher, professor in the law colleges, especially, and dealing with all the other issues on medical legal aspects of fraternity and doctor. Without wasting much time, I will request Dr. Baldwa to please start the session on telemedicines and its uses for the doctors, and what are the legal issues and challenges we face when we take care of the telemedicine part. We request the participant to please type their question answers. I will note it down, and I will make sure that all your questions and answers are answered by our eminent speakers, Dr. Moshmi Banerjee and Dr. Mahesh Baldwa. Over to you, sir.
Thank you, sir. Thank you very much. I welcome all delegates.
One thing, may I request the listeners to mute themselves, and we are going to have a question answer session where you can interact with the expert, and just after the 2 lectures. So over to Dr. Baldwa, please.
Thank you. Thank you. I welcome all the delegates who are attending this. This, of course, the brief introduction which was given by Dr. Vinit Mittal. Thank you very much. And I thank the President and the Secretary of the branch This is my book, which is more than 7,000 copies have been sold and counting, available on Amazon.in. Presentation has medico-legal aspects of telemedicine. We are not actually doing telemedicine, but what are the medico-legal aspects? Now, as per the Constitution of India, there are three separate branches: executive branch, legislative branch, and judicial branch. Now, judicial wing of Supreme Court decided in the Vishwabharati judgment that there is a legislative competence to create a special tribunals like consumer protection and CEA, and so many other tribunals have been created. But they cannot make, as per the Article 246, they cannot make any laws for Supreme Court and the High Court. So High Courts and Supreme Court, whatever laws they interpret, that becomes the law subsequently. Now, law in India is made by legislative branch, that is central legislatures, and the state legislature. Judicial branch makes under Article 141 of the Constitution. Supreme Court and High Courts, they make interpretation, and whatever in their judgment, there are two parts: ratio decidendi, that is what is being decided at hand, and obiter dictum is there are some other observations which they make regarding that particular case. And executive branch usually are given to make some guidelines, which are usually done and put up there on the government website. Now, legislative wing might omit healthcare in new CPA 2019, but it's not binding on the judiciary. And basically, that is the reason, because of the IMA versus VP Shanta 3 judgment, we are still under the Consumer Act, and which Madam Moushumi is going, Dr. Moushumi is going to elaborate upon. Now, I am on the topic of, is telemedicine routinely allowed by law? No, it's allowed only in the, it was allowed only in the COVID-19 pandemic. It is allowed to cover emergency COVID-19 situations? Yes, no, because there are contradictory messages from High Court and Supreme Court. Now, this is the case of Martin F. D'Souza, which I'm reading in the obiter dicta states, no prescription should ordinarily be given without actual examination of the patient. The tendency to give prescription over telephone, except in acute emergency, should be avoided. And there is a contradictory judgment from Bombay High Court in the Pavaskar case. Now, in this, Dhyananda patient was discharged of LSCS, and next day she was readmitted in emergency. Now, doctor was ordering, she had gone out of station, and she ordered some medicines on the phone. So, and it was a criminal case, and she was not granted anticipatory bail. Some other doctor came in and he checked up the patient. Ultimately, patient died. So this says that you cannot prescribe telephonically. So previous judgment, of course, Supreme Court judgment will prevail. That was two judgment, and this is Bombay High Court. Now, this Delhi High Court during pandemic, Yash Agarwal has approached. He said that the non-COVID patients are suffering, particularly cancer patient, chronic kidney disease patients who are taking regular dialysis, etc. And they are, so the court observed that this is incorrect. So they should be given proper treatment. This is as late as in the 17th of April 20. So now the situation in COVID is that we are supposed to teleconsult. Now, contradictory executive web portals are there. As opposed to that, we have government portals of West Bengal as well as the central government, which has a national health portal, e-hospitals. And you are aware about the CEA, that is the Clinical Establishment Act. There is a central portal also and West Bengal portal also. The National Telemedicine Network, NTN, West Bengal has its own website. And it's in the first phase where 500 PSC, CHC, SDH, and at remote and rural locations on 100 district hospitals and 50 medical college will join. 7 states have been provided with the funds. Now, this basically is the idea of the government is positive about it, because 70% live in rural area and 90% of the centers which are secondary and tertiary care, and they are in the cities. Now, major areas of telemedicine which have been adopted abroad as well as in India is teleconsultation, telediagnosis, teletreatment. That is, even without COVID, things are done on WhatsApp or by WhatsApp calls or video. And now we have Zoom and Google Meet and whatnot. The teleeducation, teletraining has become during this COVID. So this webinar is a part of that only, similar to it. Otherwise, I would have come to West Bengal, and then I would have gathered, you would have gathered in IMA house, and I would have given a speech. Telemonitoring and telesupport, this in emergency cases is very good because the doctor staying at home can see the monitoring on his whatever phone or mobile phone or computer or laptop, etc. Support during the disaster management, that becomes very important. Now, telemedicine guidelines, as you must be aware, is of the state as well as the center, but these are the common points. There's a list 0 for prescription or list O, over-the-counter medicine which are available, you can give on the audio phone also. List A with video conferencing, first consultation with proper consent, and list B, follow-up consultation, and then there is a prohibited list of the psychotropic drugs. So consent documentation recording are being stressed by medical council, and the format is the same as like name, age, gender, address, history, diagnosis, past history, and the signature of the patient. Now we'll go to one can consult on audio calls for old known patient who consult whose consent are not needed because they are your old patient as such. WhatsApp call with consent sent on WhatsApp or email of the patient party. That is most. Zoom, Google Meet, and WhatsApp video consult if needed by recording the consultation, because there is a facility of recording in this. Send prescription via email, preferably. They don't send by WhatsApp, because then if it is in email, then it remains as a permanent record. And the prescription will be definitely, it will include all the things like name, age, etc. But the consent format is already defined by Supreme Court in 2008 judgment. This has not been overruled since then. Samira Kohli versus Dr. Prabha Manchanda. The part 1 should contain the name of the patient, address, mobile number, email. Part 2, patient signature, write proper prescription with history and investigations, advise drug or non-drug treatment which you want to give on your proper letterhead, and disclose benefits versus the risk. And those risks which are more than 10%, complications like, so suppose for some drug you feel that may cause allergy, or there's got the effect of the nausea, vomiting, or bringing down the WBC, etc. Possibly you will have to tell the patient. Now, part 4 has the doctor's name, registration, and signature. This is the already Supreme Court has decided by, and we have to follow. Use of pre-printed consent. This is a National Commission judgment came on the 6th of July 2020. Now, use of pre-printed consent forms, which is usual practice of all the surgeons. It was said in this RG Stone judgment that this amounts to unfair trade practice. That you are taking the same consent form, filling in the blanks by putting the name, age, sex, and procedure, and taking blindly signature without even noting down who is the patient, what is the patient name, what are the witness name, etc. So possibly but then the Supreme Court has given interim stay on this on 18th of November 2020. So we are still in dilemma. What will be the future outlook about use of pre-printed consent forms? Now, telemedicine consent, patient has to send by email, which remains as a record, or by WhatsApp, or by suitable app where any evidence can be maintained. Alternatively, record telemedicine consultation. So if whatever you are doing by Zoom meeting, etc., it can be recorded. 2 witnesses needed if sent by email or WhatsApp. Identification of patient which you don't know can be done by Aadhaar card or PAN card. Avoid off-label use and higher and longer duration of dosage. So you must mention 3. First of all, you should be aware, like gentamicin in a mother who is nursing, or maybe drugs which are banned in the pregnancy and lactation, you should not be giving. Now you are aware about an 11.5 crore case of the Kunal Saha and 2013 judgment, and where the steroids are given an unlimited amount, and the Supreme Court said that is wrong. That was not written on the Depomedrol, whatever the information sheet is there. In 2009, Supreme Court said 2 judgment again, Martin D'Souza, and in this amikacin was given for 21 days and patient became deaf. And Vijay Lakshmi was a Krishna Kumar, where 2.84 crores were alleged for the nimesulide use for fever, which is a banned drug. Now, documentation in telemedicine. Preserve all documents like consent, written documents, advices, digital recording, record teleconsultation. Patient and doctor shall forget. Remember this. But medical documents, records will always remember, because our memory is very frail. We cannot remember each and every patient. But you have recorded it, then definitely you will remember it. Medical records are non-rebuttable evidence in court of law. Section 61 to 62, 63, 64, 65, 5, they are all about the medical records which are written. They may be secondary evidence, but for doctor, it's a primary evidence if you produce in a court of law. But 65B says even electronic records are permitted, only you have to certify that it is not altered. Remember, no records, no defense in court of law. Poor records, poor defense, and good records has very good defense. Now, this is a recent 2019 judgment, which was in the Foxy versus Union of India, where the ratio decision observes, considering the nature of services rendered by medical professionals, proper maintenance of record is integral part of medical service. So now, once the Supreme Court has put its seal on it, now we cannot ignore documentation. Now, 4 cases in sequence where they are not documented on your discharge card or indoor case paper. Rishabh, this is a very recent case, 2019 case versus Agresian Hospital. 76 lakhs were awarded. Krishna Kumar, this is a famous case you must have read in the versus state of Tamil Nadu. Again, retinopathy of prematurity was not advised on the discharge card or indoor case paper. And 1 crore 38 lakhs to this girl who was then, when at the time of the judgment in 2018, she was at that time, she was awarded this. Akash versus Sharmila, the 2012 judgment for 5 lakh, and then Sujit Rai versus Sanjeev Joshi, the 19 lakhs were awarded. Now, this I have taken one particular retinopathy, but it is regarding, like, putting DJ stent after putting removal of the, say, PCNL or whatever you are doing procedure, etc., and you want to remove on subsequent date, or putting a nasal tube, feeding tube, or whatever, some cath for giving injection, which you should remember to remove, and or tell the patient that you have to come for removal of the DJ stent or follow up like this. So the documentation and your indoor case paper as well as on the discharge card is very important, and that is only going to save you. Now, 2020 High Court, this is from Krishna Mandal, this is from state of Odisha, where they said, is it quote, doctor shall write name of the drugs in good or capital handwriting. The court has to avoid illegible scrawl which leaves doubt or ambiguity. So it is I think the judiciary is very clear. The doctors are writing illegibly in a scrawl, and they should be writing perfectly in the capital letters. Records of telemedicine, normally 3 years for children. You have to, for income tax purpose, 7 years. Xerox to be given to the patient if demanded. Hard copy as well as soft copy. Record digitally or teleconsultation. Keep consultation, consent, and prescriptions saved. Now, not issuing a bill is an unfair practice. It's a 2019 Consumer Protection Act. So I showed you that consent form, which is pre-printed, that is already been decided. This again will be a noose in our neck, where we inadvertently forget to issue a bill or a receipt. So please don't forget to issue the bill or receipt, maybe via your WhatsApp or email or whatever, but you please issue. And not arranging for a serious patient and an ambulance. These 2 things are going to be very critical in the coming years. Now, cases are being filed. This now I am facing now that cases are being filed in Consumer Commission in place where the patient lives for use some even for teleconsultation or for delayed diagnosis and treatment, and not treating non-COVID patient. Now, patients developing COVID during the hospital stay for alleged negligence, deficiency of service, and unfair treatment. Naturally, in a non-COVID hospital, they should not develop. But then if he's in incubation period or window period, then he can develop. So we are replying in that manner. At this time, the AICL, definitely the Apex Insurance will come very handy, which has branches in 26 states. It has its head office in Delhi, where National Commission and the Supreme Court is situated. So my recommendation for coming coming years of practice is that at least Dr. Moshiri will explain to you, since the limit of commission is hiked to 1 crore, I think you should take up to 1 crore, whatever the indemnity policy. Now, take home messages are CPA 2019 survives because of IMA versus VP Shanta. 2009 normally teleconsult in medicine emergency allowed. 2018 teleconsult not allowed as per the Dr. Pavaskar judgment. 2020 teleconsult and again allowed Yash Agarwal judgment. COVID-19 guidelines allow teleconsult. This is a government guideline. Guidelines, as I said, it is through the your whatever the administrative party. Like sir will agree, Dr. Manji, he can issue any type of guidelines and they are put up on the website. Now, documentation of consent, documentation of indoor case paper if the patient is admitted, if there is a discharge card, then that, or if it is OPD patient, then OPD slip. All should have the proper name, age, sex, your history, your previous diseases, whatever drugs are being taken, and whatever you are prescribing, your signature and registration number and date. And as you are aware about the drugs prescription, 0 list, A list, B list, and provided under NDPS. So don't use banned drugs, higher doses, longer duration, because there are clear-cut Supreme Court judgments about it. Right to get paid is allowed, but you have to issue the receipt. Not that teleconsultations are free; you can take the payment, but you should issue the receipt. Admit if patient needs, otherwise treat diligently on OPD basis or maybe on teleconsultation basis. Avoid delay in diagnosis, investigation, and admission for COVID as well as non-COVID patients. And government signals are positive about telemedicine. So in future, possibly government will decide, and even the Supreme Court will agree with the government, because the 70% of the population is staying in rural areas, and secondary and tertiary hospitals are 90% of them are in cities. So slowly, even the judiciary is going to agree. So thank you very much for patient listening. I hope I am in time, and I will again talk about the Consumer Protection Act after Dr. Moushumi has given her talk and summarize what are the legal nuances of it. So thank you very much, and over to Dr. Moushumi for the next talk. Thank you, sir. Dr. Moushumi, please take over.
Yeah, thank you, sir. It was a wonderful lecture and very short and crisp with the take-home message. Now, I am not a legal expert, but I have given this lecture in a national forum, National Medical Legal Forum. I'm sharing the slides of this Consumer Protection Act. But at the last, I think you should summarize and give the take-home message.
Sure, ma'am.
Yes. So today I'll be speaking on this Consumer Protection Act and what's new. Now, whenever we talk of Consumer Protection Act, we must think of this Magna Carta, because this Consumer Protection Act, and it was, the history is way back in June 12,015, so long back. Now, what is this Magna Carta? This is an English document comprising of 37 laws and a huge steps towards the equality for all citizens. And it is the most important document of all times to define our modern days laws. And this signifies that checking unfair trade practices and defect in goods and deficiencies in service. So you just remind, this is you check the words deficiencies in service, and here where we stand, the medical doctors. So now in my whole lecture, these are the points I'll be talking of: the Consumer Protection Act 1986, the changes in the Consumer Protection Act 2019, the impact on the consumers for this, and the impact on the health service and the doctors, and ultimately where we stand as doctors. So the Consumer Protection Act 1986, that is COPRA, that this was the act of the Parliament of India enacted in 1986 to protect the interest of the consumers in India, except Jammu and Kashmir. The act was passed in the Assembly in October 1986 and came into force from 24th December 1986. Now, this act it made the consumer the king. So, and who are the consumers? Now, any individual or household that uses goods and services generated within the economy for direct use or ownership rather than for sale for production or manufacturing. Now, this consumer insight is just like a tip of the iceberg, right? So hidden beneath the surface is the underlying behaviors, motivation, the pain points, the emotions of the consumers that need to be understood. So, so this is Jago, Grahak Jago, that is the Consumer Protection Act 1986. It empowered the consumers to a great extent. And this led to the establishment of a widespread network of consumer forums and appellate courts all over India. Ultimately, there was national, state and district level. There were these councils, and the aim was to promote an increase in consumer awareness and safeguard the consumers by right to choose, right to be heard, right for education, right for redressal, right to be informed, right of safety, decision to be taken by 3 to 6 months. Now, so the jurisdiction, we come to the 3-tier system of this council courts, and then the district forum used to deal with the 20 lakh up to 20 lakh cases, the state commission from 20 lakh to 1 crore, and national commission 1 crore or more. So, so the consumer courts, they do not have jurisdiction over the matters where service goods are brought for the commercial purposes. So the Consumer Protection Act 1996 now included the healthcare service into this, and now doctors are stepped into it in 1996. The verdict, this was a VP Shanta versus IMA case, AR 996 SC 550. In this verdict given by the Supreme Court, that is a medical practitioner who renders service to the patient can be proceeded for deficiency in service before the forum under this act. And now, what does this deficiency mean? The deficiency is defined as any fault, any imperfection, any shortcoming or inadequacy, quality, nature, and the manner of performance of the medical service rendered by a hospital or member of the medical profession. So, and who is the consumer in this medical profession? A patient who pays to get the services of the doctor of the hospital, or any person who pays for the patient, legal heirs, or representatives of such patients. And in case of death, the legal heir of the deceased, or any person, not a legal heir, but paid for the treatment. So that person is considered to be the consumer. But a patient receiving treatment in a charitable hospital or a government hospital free of cost is not a consumer under this act. Now, just 2 lines about the medical negligence. When we talk of Consumer Protection Act, this medical negligence has to be kept in mind. And negligence is an offense under tort IPC and Indian Contracts Act, Consumer Protection Act, and many more. And it is not providing, what does it mean? It is the misconduct by the medical practitioner or doctor by not providing enough care, resulting in breach of their duties and harming the patient who are the consumers. The thing is that complication can happen, but you should tackle it, and you should be very much diligent in taking care of the patient. The medical negligence can be criminal, civil, and contributory. Criminal is res ipsa loca, where it speaks for itself. That is when there is an extensive damage, like removal of wrong organs or keeping a mop or instrument. And civil is the act of omission and commission, that is hospital infection, lack of proper documentation, which Dr. Balwa has said, deviation from the norms, failure to attend in time. And the contributory is where the party to whom the duty is owed also contributes to the injury or damage. So with the inclusion of these doctors and hospital, there was a tremendous rise in the medical negligent cases and compensations. So the doctors say that the consumer court complaints have become a method of extracting money on humanitarian grounds, and it has become a major hassle for them to practice freely. And inclusion of health service under CPA hurts the very concept of the nobility of our profession. So the consumer bill was drafted on 20th of June 2019, and now comes a new Consumer Protection Act that was on 9th August 2019. So what was the aim is to save the rights of the consumer by establishing authorities for timely and more effective administration and settlement of the consumer dispute. And very important is the industry trends of e-commerce, that is e-dealing has been added to this. So thus appears more consumer friendly. So what has changed this new act in 2019? The first, let us compare Consumer Protection Act 1986 with Consumer Protection Act 2019. As a regulator, there was no separate regulator, but here we have the Central Consumer Protection Authority is formed. Here the consumer court, now previously the complaint could be filed in the consumer court where the seller's defendant office is located. But now the complaint could be filed in the court where the complainant resides or works. So if you treat a patient of Bihar in West Bengal, previously it was the case should be done in West Bengal only. Now the patient can go to Bihar and sue you, and you have to travel all the way to Bihar to attend the court. So this is the change. The product liability. Previously there was no provision, but consumer can seek compensation for harm caused by a product or service of the consumer court. Third is a pecuniary jurisdiction. You see, previously it was district up to 20 lakhs. Now district up to 1 crore. The state up to 20 lakhs to 1 crore. And now the state up to 1 crore to rupees 10 crores. The national level previously was rupees 1 crore. And now the national level is over 10 crores. Previously it was based only on the value of goods, services, and the compensation was relatively given according to the value of the goods and services. But in the new act, it is dependent on the value of the goods and services, but there is no upper limit of the compensation. So you can be compensated to a much more higher value. The next is e-commerce. The e-commerce has no provision in CPA Act 1986, but all rules direct selling of e-commerce is added in 2019. For mediator cell, now there is a new thing added now that court can refer even settlements to the mediator cell. So the Central Consumer Protection Council established by the central government. The MIC of the Department of the Consumer Affairs in the central government is a chairperson. The MIC of the Department of Consumer Affairs in state as a chairperson of the State Council, and the collector of the district is the chairperson of the district council. Other official and non-official members, they are nominated by the central government. Now, the investigating wing is headed by the Director General. We have Additional Director General, Director, Joint Director, Deputy Director, and Assistant Director may be appointed. And the Chief Commissioner has got the powers of general superintendents and control in respect to the administrative matter of the central authority. Now, when we come to the district forum, the president and not less than 2 or more than such number of members are prescribed in consultation with the central government. So now the more power is with the given to the central government. So they has taken up more power. So decision should be given within 21 days from the date of complaint of the file. And if the party is dissatisfied, they can appeal to the State Commission within 45 days from the date of the order. And within 5 days now to the mediator cell. Say state one, again the president, not less than 4 or more than such number of members as prescribed in consultation with the central government. And if the party is dissatisfied, appeal to the National Commission should be done within 30 days. And again, in the National Commission, the president and not less than 4 or more than such members are prescribed in consultation with the central government. So if you see the Gazette of India that has come out on 9th August 2019, the central government set rules for recruitment and removal, and the state government set rules to provide salaries, allowances, and other matters. The district, state, and the national commissions are to prepare a panel of mediators to be maintained by the consumer mediation cell attached to them. So the mediation cell are attached to each of the district, state, and national commissions. The president's age not more than 70 years and members not more than 75 years, and term of office is 5 years. So jurisdiction of the National Commission is to entertain appeals against the orders by any district forum of the state, and to call for records and pass the orders that over the dispute that has not been decided by the state commission. So the Supreme Court of India said jurisdiction of National Commission is limited and only to be exercised when the state commission fails. So the new provisions that has come over with this act is new definition for consumer, including the online purchasing, and here the telemedicine also comes in, because e-medicine, and definition of goods including food, provision covering endorsement of goods and services, definition of electronic service providers, and provision of product liability actions for goods and services, and wide definition for unfair trade practice. Now, with the help of IME and other medical association, it removes the healthcare from services, keeping concerns which are expressed by the doctors, but still see that where the doctors stand. If you see, this is a paragraph from the Gazette. It states that service means any service of any description which is made available to potential users and includes, but mind the words, but not limited to, the provisions of facilities in connection to banking, financing, insurance, transport. Now, in this list, there was the healthcare services. So this term healthcare service has been taken out from here by the request, but if you see the words includes but not limited to, so that can be extended to. So this leaves it open to the judicial interpretation. So, and it does not include the rendering of any service free of charge or under the contract of the personal service. So if you see this line again, it includes but not limited to. From this, the interpretation is that the government has just taken out healthcare from the inclusion list, but has not included it in the exclusion list. So thus, it still does not provide a blanket protection to the doctors until the health care is included in the exclusion list. So that has to be included in the exclusion list. Now, the Supreme Court judgment in 1996, which clearly said that medical services to the patient where fees are charged come under the purview of this CPA Act. So removal of the health care stands contrary to what the apex court already and legally justified. Advocate Srinivas Rao said, whether the team exists or not, a consumer who has been offered a service has the right to approach the court if he is not happy with the service, and the consumer court cannot state that it will not take up the complaint of the consumer. So the removal of the term only leads to confusion in the minds of the consumer. However, the patient and the family may approach to the higher court of medical negligence. So the patient can approach the medical council and sue the complaint against the doctor, even if he may not if he doesn't approach the consumer court. So it's not that the doctor is scot free. Now the consumer courts have centers for poor people to allow the complaint free of cost. So it was that. Now the complainant have to approach the court directly through advocates, so which will be costly. So this is CPA 2019, and this is the act on the general public. Now, why the doctors express their concern about CPA 2019, and here I need Dr. Balwa to give your summarizing your opinion. And the reasons first is the non-judicial members, they comprise of the Commission. Earlier, CPA 1986 stated that the commission at various levels will be headed by a person qualified to be a judge appointed by the State Judiciary Committee. But now, the new act does away with this and the requirement and rests the entire power of appointment with the central government. So, the next is this will violate the principles of separation of powers between the executive and judiciary. And currently, for civil cases, it solely depends on the commission members whether an expert panel opinion is required or not. And the compensation should not only be given just on sympathetic grounds. So whether we need an expert panel, that decision has to be taken by the commission of members. Now, next is higher compensation power in lower fora, that is district consumer increased to 20 lakhs to 1 crore, state consumer increased from 1 crore to 10 crores, national consumer more than 10 crores. Earlier, if a doctor does not comply with the order of the commission, he could face a jail of 1 month to 3 years and a fine of 2,000 to 10,000. But now the imprisonment is not less than 1 month to 3 years and fine not less than 25,000 is to be extended to 1 lakh or both. So quite higher compensation. The injury not amounting to grievous hurt, imprisonment 6 months or fine 1 lakh or both. Injury leading to grievous hurt, imprisonment up to 7 years and fine 7 lakhs or both. Injury leading to death, imprisonment 7 years or lifetime and fine 5 lakhs or more. Such high levels of jurisdiction denominators are really undesirable. The next is a mediator cell. So earlier the Consumer Forum, one member of the group bench had to be an ex-High Court or Supreme Court judge. But now the new bill provides a mediator cells to be attached to the district, state and the national commissions. The commissions may refer a matter of mediation and facilitate the alternate dispute redressal if the parties consent to settle their dispute in this manner. So now the doctors are now expect to go through a longer trial, first before the mediator cell for the settlement and then before the forum, if the mediator cell fails. So the doctors apprehend that in cases where higher level of compensation is involved, they will suffer more harassment. And now no penalties for frivolous and vexatious complaints. That is section 26 of CPA 1986 calls for dismissal of false complaint, even penalty of maximum of 10,000 rupees. Now, surprisingly, instead of enhancing the penalty in a case of frivolous complaint, the new act completely gave away and dismissed the clause altogether. So anyone can, Tom, Dick or Harry, anyone can complain against a doctor, but he will not be penalized if he's wrong. So unnecessary and vexatious complaints may be used to blackmail the doctors for crores of rupees without any fear of counteraction. And others are earlier, a patient could file a case against a doctor only in the states where the medical negligence happened. But now the patient can file even from different states where he resides. So now the doctor has to travel to attend the court. If the doctor fails to issue a bill or receipt, which Dr. Balwa has said, to the patient, it is considered unfair trade practice and he will be liable to face CPA. If a doctor discloses personal information given by a patient, he is also liable. So in conclusion, medical profession should internalize the quality assured health standards in the routine professional duties to ensure more protection of consumer rights. Doctors must be careful to prevent medical negligence, and we should be careful. And the ultimate aim of all doctors is to provide a proper health care, maintain a good doctor-patient relationship, and serve the society. And violence against doctors must be stopped. We condemn the violence against doctors, and it is a violence against humanity. And we all know these are the realization age-old that in nothing do men more nearly approach to gods than in giving health to men. Medicine is a science of uncertainty and an art of probability. So you may land up with complication, but that is not the end of the day. You must diagnose the complication and you should not be negligent. The next is the tender loving care. You should care for your patient. So doctors are also human. So the inner lives and the inner lives of the doctors. So doctors are also human beings. They cannot save everyone. but they will always save as many as possible. So we definitely need to support the doctors. Now, also, there are patients who come to us who are grateful to us, and they also give us presents in the doctor's day. They are so much grateful to us. They say that you are more than just a doctor. You are the friend and guide too. So here's a special wish coming in your way. They say that you are the most amazing doctor I have ever met. And strengthening, defending, and promoting the patient-doctor relationship is very important. So on behalf of the IMA Calcutta branch, we have our president, Dr. Nirmal Majhi here. So thanks, sir, for supporting us to have this webinar today. And the entire team, I thank the entire team of IMA Calcutta branch and all the members, all the doctors who have participated in this conference, the entire team of Apex Medico Legally, especially Dr. Mahesh Balwa from Dubai. He's an excellent legal expert, and Dr. Vinit Mittal. Thank you, sir. Namaste. And now requesting Dr. Mahesh Balwa to take up. He's a globally renowned legal expert to summarize the take-home message for the doctors where we stand under COPRA 2019. So over to Mahesh Balwa for your expert comments, sir. So please, over to you.
Can't hear.
Yeah, now they are unmuted now.
Yes.
Thank you so much, Dr. Moushumi, for your elaborate talk. And I will summarize. First I summarize and then I will give my opinion. Now this is basically what is the take-home message for CPA 2019. CPA 2019 survives because IMA versus VP Shanta 3-judge judgment exists. It's not overruled by repealing 1986 Act. Claim of compensation, as you rightly pointed out, is 1 crore, 10 crores for state commissions and more than 10 crores in national commission. Patient can file case where he lives or works. Decision must be within 90 days. That is section 38, subsection 7. Then review of order in the same court is now possible under section 40, 50, and 60. Experts are available, of course, at the discretion of the judges, but section 66 provides for experts. Limitation is the same as the previous act for 2 years. Revision is removed. Only appeals to the higher court are allowed, but you have to deposit 50% of the amount. This is very, very problematic because suppose the state district commission awards say 1 crore, then one has to deposit 50 lakhs. Now here where the Apex insurance is going to come handy. Mediations is possible, but both the parties have to agree. It's not compulsory. 74 to 81 is regarding mediation. And if both the parties agree, then it is goes to mediation cell within 5 days. Otherwise, it is goes with a normal hearing. Advertisement, endorsement, not issuing bill, not providing ambulance is unfair trade practice, section 89, and 50 lakhs for the first offense and the 2 years of jail. And for subsequent offenses, first offense is at 50 lakhs and subsequent offense is, first offense is 50,000, 5 lakhs, and then subsequent offense is 50 lakhs and 3 years of jail. So all in all, you are under a big trap, and to come out of the trap, I think unless you challenge your own degree, it is not possible. It is not possible to give every doctor gives the best possible. Who doesn't want good practice? So the only way is to insure yourself and with the indemnity policy and take the risk policy. So they have the 26 branches, 26 states, and each and every state you can be represented well. And in the Delhi, they are having their head office. So there the National Commission and the Supreme Court is there. And in fact, about this the RG Stone judgment, we have taken the initiative and got the stay also. That pre-printed consent forms, etc., is so we can. If you want to challenge, some of you from West Bengal, you can approach our representatives and they will challenge whichever section you feel, and we will try and draft the thing. But we need some IMA, not an individual person. Say, IMA West Bengal wants to challenge as someone, as you said very rightly, section 26 is removed. Now, why the validity of the 2019 Act, whether the healthcare, which was, or even the IMA versus VP Shanta, is 3. So now they will appoint a 4 or 5 judge bench. So this is very important. So somewhere there is a big role of Indian Medical Association, particularly those are you people have the birth of the IMA in Calcutta. So naturally you have first right to handle all such situations, and on your behalf, our Apex Insurance Consultant Limited definitely will take up.
Sir, there is a question for you. Now, many of us think that we can never be sued by Consumer Protection Act anymore. I mean, from the Consumer Forum anymore. So, what is your?
I'm already getting cases. I have showed you. There is a case in Odisha where 7,000 were paid for the abdominal CT scan, contrast CT scan, and he did again, and some abnormality was found in the kidney by that center. Then he went to Delhi, did it again, and no abnormality was found. He has filed case of 22 crores. Then yesterday only we dealt with a case from Mumbai, when the district forum, state commission, he has filed 2 crores case. This is again a CT scan center. That doctor told me, I'm running 3 centers. If I sell 1 center, then it will amount to 2 crores. So this is a
we
big.
We are still not out of it.
Yeah, no, we are not. We are absolutely in it. No, the judiciary always will have to follow under Article 141. That is terror diseases. The IMA versus VP Shanta of 1995 judgment still remains not overruled so far. So unless IMA goes against that particular judgment, we are there. Even in the 1986 judgment, the act also, the healthcare was not explicitly there. So dropping it does not, as you mentioned very correctly, it is not excluded. It is not in the exclusion list that you are not included. So it amounts to nothing. See, if they had written except healthcare services in section 2, subsection 42, which defines services. So your position is the same. The definition is the same old definition 210 of the 1986 210 section said the same thing. So where is the question of you getting out? I have told you about in a slide about the legal validity. Whether in 2003 Vishwa Bharati judgment, which if you want to see again, I can show you again that judgment. Basically, that Vishwa Bharati judgment in 2003, this is legally valid. So where is the question of now legal validity? Legal validity is already there. And all these judgments which I have shown in my presentation, they are pertaining to Supreme Court. They are not pertaining to some smaller court. So you cannot ignore them.
Okay, sir, I think there are certain questions in the chat box.
Yeah, you can come. Yeah.
Right, sir.
Why can't you take up the question and answers? There are certain chat box questions, I think so.
In the chat box, good evening, everybody. Thank you, sir. Thank you, madam, for the excellent presentation. Dr. Mangalik has put on some questions regarding the removal, and I think Dr. Baldava has answered. I don't see any questions in the chat box. Anybody can come up, any questions from the audience? Any questions from the audience, please?
Now, I can ask you, Dr. Balwa, suppose
please go ahead.
In a telemedicine communication, if now that is being done because in this COVID scenario, but suppose I'm telling you, in case of gynae, our president is also a gynae. I mean, he has He is also a postgraduate from Gynae. Now, suppose a patient complains of irregular bleeding PV, right? Now, that may be, without seeing the patient, that may turn up to be a case of ectopic also, right? So,
Yeah.
just listening to the patient, right? Now, if you don't, now if the patient first consultation you have done on telemedicine, right? Now, if the patient says that he or she doesn't want to come to the chamber, so what are you going to, can you refuse the second consultation? Or can you say that if you don't come to me, I need a clinical examination? And then the patient may say that is the reason of the COVID situation. I'm going in for telemedicine. I'm paying you, doctor. I've already paid the fees. Right now, usually in telemedicine, they first send the fees and then there is consultation. So is the doctor liable, or if the patient doesn't want to come up? So, I mean, your comment about this.
Yeah, the first thing is that once you are such a scenario is there, first of all, whatever consultation is there, that you can time limit it. You may say that you can see yourself, observe yourself for 2 hours or 4 hours, nothing more than that. After that, if you don't get relief, you have to visit. Either get done CT scan, or if CT scan, generally gynec people don't prefer MRI or ultrasonography or whatever other method which can prove or disprove your diagnosis. CT scan is out of question because of the pregnancy. And second thing is that, of course, you can always time limit. You can write down below that you have to report back to me on telephonically or by some method in 2 hours or 4 hours. After that, you don't find, then you have to come physically for examination.
But if the patient already pays in our account,
paid
and then if you say that I will not see you if you don't come to my chamber, then the doctor will be liable because the patient first pays in the account.
You are putting a rider that it is this consultation is valid for 2 to 4 hours till you revert back. So if that you down. And also write down your investigations which you want to. Urine pregnancy test or beta
HCG and all these.
HCG, etc. All these things you should put, so that you should now with these newer things, you should be more cautious. You should not bother whether a patient is going to spend, or you should be more cautious and careful. And here in our case, it is not the question of money, it is a question of reputation as well. See, one patient.
It's not the question of money, it's a question of reputation now.
Reputation, which is more dearer to us than our own body.
Exactly.
Our own body, we don't love that much.
Another thing, our president sir is also here as Gynae, the medical abortion drugs. Now, the medical abortion drugs, he being the president of this medical council, knows that you have to fill up the form C, you have to fill up the form I, and then the medical drugs has to be prescribed.W that can't be done through the telemedicine. You cannot prescribe a medical abortion drug in the telemedicine. You have to call the patients. But I find that there was certain telemedicines done, just prescribe the 5 weeks or 6 weeks pregnancy shown by sonography, and the medical abortion drug is prescribed by telemedicine. Now, what is your idea about this? I think that this shouldn't be done, because the patient should come up in front of you, fill up the form C, fill up form I, and then give the consent and do it.
In the first consultation,
I think so.
First consultation, Dr. Moushumi, you are right. First, but the consultation, once the person has paid, it does not mean the patient has paid forever. See, you can always write the number of hours that after this, these are the things you are expecting. So for that, you have to come personally.
A question here, sir. Can the doctors refuse second consultation, teleconsultation, sir?
On what basis?
Suppose I have done a first suppose the doctors have done a first consultation and the patient is not listening to the patient. The patient is not listening to doctor. Can he refuse to do a second consultation, sir?
Then you write an email. That's the reason email is very essential. You write a clear-cut email that you are not consulted after so many hours. So I'm abandoning my services.
So the take-home message for the team here is that what sir is saying, that after first teleconsultation, you provide a day that come after 2 hours or 3 hours or 1 day. If the patient does not come back to you after 1 day, you write an email to that patient that you have not revisited me for the follow-up and for the treatment. Hence, I am not liable to
ready to
the-
continue the further treatment. And my treatment now stands abundant.
Yes.
So please don't, whatever medicines you are having, please discontinue.
So please understand, friends, here is very important take-home message. That is just not what we do. We think that the patient will come back to us. That's when we are in the chamber, that's a different matter. But when we are doing a teleconsultation, and when we have done a first teleconsultation, and after a particular certain hours or certain days, the patient does not come back to you, in order to safeguard ourselves, we have to write an email to the patient saying that since you have not come back to us, hence we abandoning your treatment, or we are not taking care of you any further. And any responsibilities, any problems coming up further is not my responsibility, right, sir?
Correct, sir, correct.
Dr.
And this should
Vinay,
be this should be in your teleconsultation medical, whatever the prescription is there, below that you write that the number of hours for which the prescription is valid. Now in Dubai, I had a chance to accompany both the children are doctors here. So they face such situations too often. So the prescription is valid for 1 hour, 2 hours, 1 day, maximum 3 days. Maximum 3 days. So if they don't report back on the email, then the prescription is not valid. And here everything is, of course, barcoded. So if the patient goes after 3 days for getting the medicine, he is barred. For not only he is barred, suppose I have prescribed the medicine for say 1 month. For 1 month he cannot get the medicine.
Right. Here, sir, here one question is, sir, can we take the consent form like madam told regarding the consent form regarding for medical abortion drugs? Can we take these consent forms on the mail, sir?
Yeah.
Duly signed by them?
Email. See, always take on the email. See, all this documentation, in fact, should be preferably done on email basis, because then it becomes permanent. No one can delete email. Even if you are deleted, the records are there. You are aware about it. If anyone sends email, it is as good as, even the Supreme Court has agreed to it, that email conversations or the trail mail is valid for any commercial or for medical purposes.
Sir, one thing, whenever we certify something, we get the self-attestation done. I mean, the patient signs and the doctor does the self-attestation. Suppose a child comes and she is less than 18 years, but she comes and tells me that she is over 18 years, or she is 19 or 20, right? So it is very difficult because she doesn't carry the ID card with her. So I am 18 years. Suppose in case of say unsafe sex, or in case of rape and all this thing, if she is below 18, then you have to report to the police, right? So now then you have to get her write down that I am so and so, I am 17 or I am 20 years old, and get it signed and attested by the doctors. Then the doctor is protected. Because so in this case, these cannot be done. Can it be done by over telemedicine? It becomes very difficult.
My wife is a gynecologist. Without Aadhaar card, PAN card, or birth certificate, we don't entertain MTP at all.
Exactly. So that is another take-home message. That is very important.
Patient has got an ectopic or bleeding so profusely that is life-threatening. There is no question. You have to ask for their
ID card before medical abortion.
Any identity,
any abortion.
With you are satisfied.
And specifically if they are adolescent or younger. Now there are questions from comments from Dr. Mangoli. He is a very renowned child specialist.
I'm aware.
And I am a
about
Calcutta member. So Dr. Vineet Mittal, can you kindly read his comments? And we have our president and the other members. There are
Dr. Arun Manglik has in fact told about the new CPN 2019 that the IMA should take it up with the Supreme Court for the exclusion of the medical services, especially the exclusion of the medical services from the Consumer Protection Act. That's very important part that we should take it forward. Second thing which he has commented about, that the in case of frivolous complaints where the complaints are false, that section also has been removed. So in case of frivolous complaints or in case of fictitious complaints, there should be a provision where the compensation should be given to the doctor in tune with the whatever is the compensation package. These are two things, observation by Dr. Manglik. And
I totally agree with Dr. Mangale. I think he was there in that IMLIA conference at various forums, and he's a very enlightened person. And I believe IMA West Bengal should take up. There are so many IMAs there, all of them join together and should approach straight away Supreme Court for review of this particular judgment.
Yeah, for review
IMA
that
West
so that Consumer Protection Act is included in the exclusion list and we
Yeah.
are protected. And
Yeah.
number two, for frivolous complaint, that the compensation earlier was there is now no more there. So that has to be
No, don't
taken
dilute
care
for
of.
about that. Forget about
Yes.
that frivolous complaint. I
Mhm.
think a big job will be done if it is excluded.
Yes. So that is the
Big
take
job will be done.
That's a take-home message, friends, that still we are under the Act, Consumer Protection Act. We are not excluded from that. And I'll just like to ask one question to Dr. Valdava. So what do
Yes,
you
sir.
think is the load? What is the load you think, sir, as a present on the medical fraternity? What is the percentage of cases you think, and what is the approximate load, sir, against the medical
Sir,
community?
every
Dr. Vinay,
whatever.
after Balwa, you take this opinion also from our president because
Yes, sir.
he is the
Yes, sir.
president of West
Right, sir.
Bengal Medical
Right, sir.
Council
Yeah,
dealing with such
yeah,
cases in the
Right, sir.
meetings.
Right, sir. Right,
First
sir.
of all, the first comment is that as compared every previous year, the patients are becoming better litigants. That is the first comment. So the generally my idea is in any district forum, 1% of the cases are against doctors. 1% out of 100 cases, one is against doctor. This is what is my. Of course, I have done certain studies, but they are very old. That is done somewhere in 2015, and now 2020. The percentage will come a bit higher than what I am trying to tell you. Of course, West Bengal Medical Commission, Medical Council, basically was 20 years back or 30 years back, couple of complaints were there. I think they are flooded with complaints, and I think Dr. Maji will agree with me.
Right, sir. So
I'm
thank you, sir.
agreed.
So,
I'm
sir,
agreed with Mr. Moez Valdava, the international expert, and undoubtedly today's excellent, wonderful interaction and our medical community will be enriched through the discussion. And next legislative wing might omit healthcare in new CPA 2019 is not binding on judiciary. Our second next speaker, Madam Dr. Dev Banerjee, our Honorable Secretary of Indian Medical Association, Calcutta. You can proceed.
thank you, sir. So, sir,
Right.
Dr. Maji, sir, one question, sir. Dr. Sir,
Right, sir.
sir, one question, sir. Now, sir, with seeing the facts, what Dr. Baldava said and Dr. Moshmi, they said, sir, what do you think, sir, should be our IMA as a Calcutta branch should take some steps to forwards to?
Certainly, we should take the necessary steps, and through West Bengal
Apex
Legal
Insurance, you can
Council,
they
Indian
can
Medical
follow up.
Calcutta branch, and state branch, all together, we can proceed, and we can request, we can submit our recommendation to Honorable Supreme Court Judiciary, the highest judiciary of the nation,
Right, sir.
and we can correct.
Thank you, sir. Thank you, sir.
This.
Right. Thank you, sir. So,
Thank you, sir.
friends,
Thank you.
I will just request the Apex committee to Apex Consultancy Services to run their presentation for 5 minutes. And what are the facilities they are forwarding to the doctors, and what are the facilities they are giving in the sense? I have been a part of this for last 15 years and have a personal experience with this and with this Apex Consultancy, and they have been standing next to me in every case. I have been through a lot of problems. I think you must be remembering 2008 case when there was HIV death in Mission of Mercy Hospital. I was a person who had been framed actually, and then the hospital sued me, and then the case ran for 10 years, and this committee was there, these Apex lawyers were there besides me every time whenever I needed them. So I request yes, ma'am. So
Yeah,
I request,
but I want this medico legal platform to continue with IMA Calcutta branch And we will be doing such session. I request Dr. Balwa to spend some more time with us. Your wonderful interaction, and it
Very
was very
nice.
enlightening. Very enlightening. You're as a senior. We need senior persons like you, and we really liked it. And we want this Apex and IMA Calcutta to go hand in hand, and we will be having regular, say, medical legal platform. In fact, I suggested that the three important things, that is the consent, the counseling, then the documentation, then how to disclose a bad news. Now, if any emergency death in OT table happen, what will the doctor do in emergency? So these are very important issues, Dr. Balwa, and we want you to,
Yes, I agree with you, ma'am.
subsequent session, we want you to be with us and discussing this.
Yes, ma'am. Yes,
Where
ma'am.
our doctors will be benefited.
Thank you,
Yes,
ma'am.
ma'am. I'll be there.
Thank you, ma'am, for the nice thing. And I will request the Apex consultancy to
Yeah, Apex consultation. This is just
please run your presentation so that the
Yes.
doctor fraternity can understand and enrich by your coverage.
Please.
Then I will request Dr. Moushumi De to give a closing remarks, and Dr. Nirmal Maji, our respected president, to close the session. Yes, Jay
Thank you.
Pandey.
Thank you very much. Good night to everyone.
Jay Pandey, Apex Consultancy. Mr.
Pandey.
Just we
Can't
request.
hear.
yeah, they
No sound, please. There's no sound.
No sound.
Mr. Arora.
Vijay Arora.
Till
Arunda, thank you for coming and making this very
Thank you, sir.
interactive, Arunda.
yes, yes. So this Apex consultancy, as Dr. Baldava said, that it was covering almost all the states in India. They have lawyers in all the states. They have expert lawyers in district courts and the state courts and the higher court. And
Ajit sir,
Yes, yes.
yes, so please.
please run the video, please.
Huh?
Play the video.
Yes.
I'm
visible.
asking the operator, sir, actually.
Awards and accolades. More than 100 branches of Indian medical associations and different medical associations recognize us as their official risk management partner. Innovative Zone, most trusted brand to watch in 2019. Business Connect, Consultant of the Year. Business Site, Most Admired Consultant to Watch in 2019-2020. India 5000 Best MSME Award, 2019-2020. Consultant Review, Most Promising Insurance Consultant. Right Choice Award for India's Most Promising Risk Management Group 2020. Asia One, Asia's Greatest Brands and Leaders 2019-2020. Business Side, Most Valuable Brand to Watch in 2020. MSME, Chamber of Commerce and Industry, Award for Excellence in Innovation in Healthcare Industries 2020. With Apex, a medical professional is free to take his professional decisions and spend more time growing his business. We are the first and only in the world to create a complete professional shield of security around medical practitioners, fighting the case, compensating the patient. We are an expert solution to create a more healthy doctor-patient relationship. Our affordable and reasonable pricing has encouraged more medical practitioners to opt for safe and secure practice. A
Ajit bhai,
safe
Yes,
and
ma'am.
medical professional can
হ্যাঁ
deliver
ওই মৌসুমি মৌসুমি হচ্ছে আইএমএর সেক্রেটারি আবার আমাদের গাইনোকোলজিস্ট ভীষণ জোরে জোরে বলছিল না, ও তো একটা
হ্যাঁ
প্রেজেন্ট।
বুলবুলি,
হ্যাঁ বলো।
বুলবুলি ওয়েলকাম।
ওয়েলকাম।
ভালো লাগছে
Thank
তুমি
you.
এত রাত অব্দি আমাদের সাথে আছো।
হ্যাঁ, আর
খুব
বেশিক্ষণ
ভালো
থাকতে
লাগছে।
পারবো না। Another 15 minutes, তারপরে চলে যেতে হবে।
এই তো আমাদের হয়েও যাবে। থ্যাংক ইউ বুলবুলি।
থ্যাংক ইউ।
বুলবুলি was a very active member, মানে আগে তো শিবকুমারী মেমোরিয়াল ওরেশন সবসময় বুলবুলি করতো আমি ক্যালকাটা ব্রাঞ্চে। এবারে
আরো
বুলবুলি
And senior member.
সিনিয়র
of course.
মেম্বার। হ্যাঁ হ্যাঁ হ্যাঁ।
আগে অনেকই কিছুই করেছি, বহু বছর এক্সিকিউটিভ মেম্বার ছিলাম।
আর আমাদের বেঙ্গল অবসেটিক গাইনি সোসাইটিতে আমি এখন ভাইস প্রেসিডেন্ট। দিদি পাবলিক অ্যাওয়ারনেস প্রচুর করছেন। এবার দিদিকে নিয়ে আমরাও আমি ক্যালকাটা পাবলিক